All right. Hello, everyone. I think it's time to start. Welcome to today's webinar from wherever you may be watching. My name is James Paniki. I'm a senior editor with MLEX, and I'm speaking to you from our offices in Naarm, Melbourne, Australia. And if you'll allow me just 20 seconds of self-promotion, MLEX is a LexisNexis media company. Our reporters around the world produce fiercely independent journalism, and our specialty is regulatory affairs. In Asia, that means first and foremost data privacy and security and competition, which we tend to refer to with the very American word antitrust. And you don't need me to say this, but what an incredible time we're living through in antitrust regulation at the moment. The digital world is developing at breakneck speed, leaving regulators doing everything that they can to catch up. Sometimes their efforts are visionary, and at times there are missteps, but that all adds to the drama of the area that we're all working in at the moment. Here in Asia, we're certainly aware of the reverberations of battles being fought in North America with the increasingly muscular stance of the FTC and the DOJ in this area, and of course the European Union, where the Digital Markets Act, or DMA, is casting a very long shadow. That said, the regulatory response to the competition challenges posed by the digital sector has been uneven in our part of the world, often country specific and often tailored in a way that takes into account local dynamics and local players who have been able to take on the Silicon Valley giants. However, there are plenty of common themes to discuss, and that's what we're here to do today. And let's get the Latin terminology out of the way up front. For those unfamiliar with the term ex-ante, we're simply referring to regulation that is forward-looking, and we will no doubt be using this term often. What ex-ante means in the digital world is regulation that takes into account not just the competitive restraints that already exist in a given market, but also look forward to the world as it may be in a few years' time, when the startups working out of a suburban garage today have become the giants of tomorrow. As to whether ex-ante regulation is needed or can even be legally achieved, well, that's what we're here to debate. We've got some great panelists lined up. As you can see, all of them are brimming with ideas and opinions about what lies ahead. Before we get started, though, let me firstly acknowledge Access Partnership's work on these online conferences. These are wonderful opportunities for those working in these fields to be able to compare notes on global issues. Today's webinar is being recorded and is also being live streamed on Access Partnership's YouTube channel. The recording will be made available for those of you who'd like to revisit today's discussion or share it with your network, or dare I say, with your ecosystem, and we certainly encourage you to do that. Also, very importantly, we want this to be an interactive session, so please feel free to drop your questions in the chat box, and we'll try to address as many as we can during the Q&A session. I'll list today's guests strictly in alphabetical order. Masayaki Atsumi is partner at Miura & Partners. He's joining us from Japan. He has qualifications to work in 3 jurisdictions and has been involved in many multi-jurisdictional antitrust issues. Dr. Andy Chen is the vice chairperson of the Taiwan Fair Trade Commission, formerly a professor at the Law School of Chung-Yuan Christian University in Taiwan and the dean of the law school there. Kirsten Webb is a Sydney-based partner with Clayton Utz. She's a specialist in competition and consumer law. She's worked on several cross-jurisdictional matters, and very importantly for us, she also agreed to step in at the last moment with a family emergency affecting our scheduled panelists. We're very lucky to have Kirsten with us today. And Yan Yu is a partner with RBB Economics. She's been providing economic advice on competition for the past 15 years. She's usually based in Singapore, but today joins us here from still a rather chilly Melbourne. Now, we've all agreed to keep today's discussion on a first name basis to make it as informal as possible, and I encourage all participants to see this as a rowdy session around a lunch table. Feel free to jump in at any stage of the discussion. Don't wait for me to ask you a question. Now, Andy, we have to start from you, Andy Chen. You're the regulator at the table, so we have an absolute laser sharp focus on what you have to tell us today. The TFTC released its white paper on competition policy in the digital economy. So all of these issues are no doubt still very fresh in your mind. Could you please tell us in just a few words what the white paper examined and what your conclusions ultimately were?
Thank you, James. Thanks to everyone. Thanks for having me in this event. I think I must stress at the beginning that part of my talk is my personal thought and may not necessarily represent the enforcement position of the Taiwan Fair Trade Commission. I think, as James had just mentioned, we released a white paper on competition policy in the digital economy last December. And the purpose of preparing this document is to let the business in Taiwan know where we stand in terms of the enforcing competition against or to regulate the digital sectors. And we would like to also use this opportunity to kind of sorting out what has happened in Taiwan. For all those issues that has been widely discussed or debated in United States or in the EU, whether those issues has really taken place in Taiwan. And if it does, then to what degree, what kind of measures should we take to regulate those issues? So there are three main points we try to examine through this through the preparation of this document. The first one, we want to see the degree of competitive harm from the competition issues in the digital sector. The second one is we want also like to review whether those issues could be addressed within the current analytical framework in competition law in Taiwan. And thirdly, we try to figure out how can we strike a right balance between maintaining market competition and the market innovation. I think innovation is especially important in the digital sector. There are 14 issues we cover in the white paper, including, for example, the two-sided market and the market definition, self-preferencing, most favored nation clause that are practiced in the digital sectors, and killer acquisition, algorithm and collusion, data privacy and the market competition, and revenue sharing between the digital platform and the news media, and also digital unfair competition, for example, online false advertisement or dark commercial pattern. And we did make some policy suggestion in the white paper. The first, we find out that most competition issue associated with the digital economy, especially arising from digital platform, could actually be addressed within the existing analytical framework. Of course, we need to strengthen our enforcement skill in terms of digital technology. So that's the reason why we have spent more budget on procuring the software, hardware, and also the human resource training in terms of knowing better the whole industry. The second conclusion we suggest to the Commission is that the TFTC might, at this moment, commit to establishing market contestability. By that, we mean that we should devote more resources in facilitating the entry of new competitors. And the third finding or third suggestion is that we emphasize the importance of regulation and its relationship with local nexus. The reason for that is that because we find out that the differences between business model, market structure, or even legal framework among different countries may have significant impacts or asymmetrical impact on the result of enforcement. So for example, I will make some example. For example, the popularity of Google ecosystem may vary significantly among Taiwan, Korea, and Europe. And I think most of you might be very familiar with the pre-installation of app pre-installation in the Google case. And in that case, I think the EU Commission emphasized very much about the status quo bias that existing in the user. Once you use the Android system, it might be very hard or challenging for you to switch to other system. But actually in Taiwan, when we investigate in this case, we have conducted a survey among the user in Taiwan. The status quo bias may not be that strong in Taiwan. And we find the user in Taiwan switch quite frequently or regularly among different systems. And also we emphasize the difference in legal framework. I think because the difference in legal framework might have different impacts on the jurisdictional power and also the result of enforcement. So, for example, the Korea Fair Trade Commission may have wider jurisdiction over digital issue than the Taiwan Fair Trade Commission. And also, for example, the labor law, or even, for example, the enforcement principle against the no poach or the non-compete clause in different countries may significantly restrain or limit the cost of entering into the market. And that will also significantly impact the competition, especially potential competition in the digital sector in different countries.
And Andy, sorry to interrupt. Sure. It's just there are so many interesting strands there. I can't wait to discuss them all.
Sure.
I take your point that enforcement in a way involves, I suppose, the TFTC itself equipping itself for the challenges that lie ahead. If, however, you could wave your magic wand and obtain new regulation, new legislation, is there anything that you would ask for from the government? What tools do you feel that you still do not have in your toolbox?
I think, of course, the digital technology training within our agency, and that will inevitably require more budget. And actually, we spend more budget on these aspects. We increased the budget by 15%. But still, I think in terms of what we need to do, there's still a significant gap. And secondly, in terms of the legal framework, I think we still need more investigation power. Actually, currently, we are revising our Competition Act, and we have put a clause into our act that is allow the TFTC to conduct market inquiry. I think market inquiry is maybe quite common in many jurisdictions, such as Japan, EU, but not in Taiwan. We can only conduct market inquiry only when we need to conduct a case investigation. We still cannot conduct a general industry investigation or survey. So we hope we could have this kind of legal power, because it's very important for the investigation of digital market. Yeah.
Andy, I assure you, however, that you're not alone among regulators in needing more funds. I think that is a very common complaint that we hear quite a bit. But Masayuki, let me ask you now. I know that there are similar discussions underway in Japan at the moment as well, particularly when it comes to the mobile ecosystem that Andy just mentioned there. Remind us where things stand in Japan at the moment in these key areas.
Sure, thank you very much. And it's a great pleasure to speak with you on this very important and interesting topic. So Japan is trying to introduce a couple of ex-ante regulation on the digital platform. And the first one is already still there. In 2021, Japan already introduced a new law to promote fairness and transparency for business users. This imposing various disclosure obligations on the platform specified by the government. For example, they need to disclose the terms and conditions of its use, and also main factors to determine rankings. And if platforms change its terms and conditions, they need to disclose reason for changes and reason for rejection of the use of the service. And platforms are also required to take necessary measures to handle the complaint from the users on the platform. So that's already there. But in addition to that, the law to increase transparency, as James suggested, the Japanese government is considering new ex-ante regulation on mobile ecosystems. So the Japanese government also published a white paper on this point this June that identifies various competition issues within the layer structure of the mobile ecosystems, starting from the mobile OS systems and mobile app stores, where, as you know, Apple and Google takes a large amount of market share. And the issues identified in the report are pretty much global issues that mirrors what Andy suggested, what Andy is specified in their TFTC report. For example, regarding the app stores markets, the report mentions there lack competition among app stores, especially in iPhone, where users can download apps only from Apple's app stores. So they restrict the side loading from other app stores or from the web browsers. And to tackle these kind of issues, the report concluded that existing antitrust law enforcement is not enough, and it's too slow and difficult to analyze the digital market, and proposes ex-ante regulation on the mobile ecosystem market.
So but Masayuki, that is what you would expect from I suppose lawmakers or a government regulator. What's your view though, Masayuki? I mean, you're a bit more cautious on the need for ex-ante regulation, right?
Correct. So I believe introduction of ex-ante regulation on the digital market should be analyzed carefully, as it has many downsides on this. And first of all, I generally oppose to the idea of ex-ante regulation, as it will increase the risk of over-enforcement. And especially in the digital platform market, where it is very dynamic market. And if you introduce a regulation which reacts to the conduct flexibly, this will cause a chilling effect on the businesses, and that will stifle the innovation by the digital market in the long run. And also, this is, sorry, I will continue, but this is particularly true in Japan and APAC market, in my opinion. I'm not an economist, so I don't know that there is any empirical study on this, but I think from my experience, Japanese companies are more conservative than Western companies in terms of the compliance of the ex-ante regulation. So if there is any catch-all clause on the ex-ante regulation, they're on the safe side and they try not to violate any law. So that may stifle the innovation by the players in the Japanese markets. That's particularly a dangerous situation, in my opinion.
So, Masayuki, you don't feel that, for example, if a kind of a replica of the European Union's DMA were introduced tomorrow in Japan, you would not necessarily see that as a positive from your perspective, obviously.
Correct. Yeah. I don't think that fits the Japanese market and Japanese companies' mindset in terms of the digital market. So that's my opinion.
Okay, Jan, we're relying on you to give us the dispassionate, analytical, scientific view that only an economist can provide, obviously. Maybe let's start with what is arguably the jurisdiction that we know the least about for obvious reasons, and I'm talking about China. I wonder whether the soul searching about competition that we're going through in so many jurisdictions in Asia when it comes to within digital ecosystems, I wonder if that's really relevant to China, given that there are big players like Alibaba and Tencent that effectively are ecosystems in their own rights, right? And so there is competition between ecosystems. So there doesn't have to be the same level of soul searching about competition within those ecosystems. Is that a fair summary, or have I got it wrong?
Fairly reasonable. Thanks, James, and thanks everyone. Great to be on this panel. Yeah, I'm really happy to hear different sound of voice, to be honest, coming back from Europe and UK. And China indeed is one of the jurisdictions often being left out by many other countries for good reasons. But on the digital sector, I would say there's interesting lesson potentially to be learned from the Chinese experience. People who followed to some degree would probably notice that before 2021, there was hardly any intervene by the authorities into the whole sector. Merger filings were not accepted by SEMA due to some VIE issues, and there was really massive expansion in the sector by large players or controlled essentially by Alibaba or Tencent. So we have seen a huge growth in the sector with innovative products, better services, convenience to consumers over the years, which was great. But equally, at the same time, you almost see that there are two competing massive ecosystems where Alibaba and Tencent each tap into each other's territory. And the way they did that through acquiring smaller startups, successful players in different segments, or taking minority shares, or developing their own products. So you would thought that in that kind of environment, new players wouldn't come in, but that wasn't the case. In fact, at later stage, we actually saw ByteDance Group, known for their TikTok products worldwide, emerged as another ecosystem. And then within those large ecosystems, you see many smaller ecosystems, for example, Meituan, which is equivalent to the Deliveroo in the Western world. However, they have really extended from food delivery to other life support, facilitating services for neighborhood, even community shopping, for example. So those are scenarios, I would say, phenomenals you don't see in other countries, partially because the Chinese people tend to be more willing to try new apps. They're probably less sensitive about privacy control or privacy protection, data protection. But I think now people are becoming more cautious about that. So there is hugely benefit, I would say, coming from all this regulatory talks and developments. People are becoming more switched on with potential harms. And then when SEMA all of a sudden started to crack down the sector, you see everything changed overnight. And pretty much all the major platforms were under scrutiny. If we're looking at the Chinese market now, I would say it's pretty dying. Not much innovation going on, and the growth clearly is declining. And Alibaba is now being, I would say, restructured or divided into 6 groups. So I guess the question is it because of lack of regulation causing less competition or more regulation? I mean, that might be potentially a case study if anyone later on take, empirical and a comparative analysis. Particularly now, we know in the EU and UK, both jurisdictions have already passed the ex-ante regulation. But they are very different. So, I mean, from economist perspective, there are some commonalities worth highlighting. If you look at this conduct of concern or issues they're interested in, many of those were originated from legacy cases. So it wasn't that they have been evolving with the growth of the digital sector and identify really cutting edge, new issues, new ways of potentially abusing the market. No, it was all very old conduct. And then there is no longer a prerequisite condition for firms to have dominance in order to comply with certain rules and regulations. And we can see that you can argue whether UK system will still allow effect test argument analysis, but clearly there is a focus shift from effect to competition to fairness of competition and market contestability. And as economists, we often wonder what that means, to whom this is considered fair, and what is contestability actually applied to, what it implies. And so when we don't have sound economic framework, for example, the consumer welfare standard, all of those questions could become quite arbitrary. And to business, it would become uncertainty in some degree, and potentially, as Andy pointed out, and then as Masayuki pointed out, the innovation might be curtailed as a result of those regulations. But we are at a critical stage, I would say. I mean, it will be interesting to see how everything pans out in Europe and UK. The big question, I think, is still worth asking, despite the fact that people over there seem to have way past the debate whether a new tool is required. But we should still ask, well, what is the goal? What does agency wish to achieve? And do they simply want to open up the market to allow national players to come into the space? Or they want to bring in more smaller players because they're not happy with innovation driven by large platforms? or something else. So I guess a lot of those questions are unanswered at this stage. Maybe next year if we have another panel.
Yeah, well, that's right. We'll have to book some time in right away. This is fascinating. The situation in China is absolutely fascinating because you do, as you've rightly pointed out, have a before and after that severe intervention by SAMR. And that really gives you a sense of, absolute unbridled innovation on the one hand, regulation, arguably over regulation on the other. What are the effects on the economy? And that is a fantastic case study for all of us working in this area. Kirsten Webb, is the ex-ante discussion resonating in Australia in the same way that it clearly is around the region?
Thanks very much, James. That's a really good question. And as with the other panelists, very happy to join, albeit very late, to this panel and this super interesting topic. In Australia, people who've participated in the earlier webinars arranged by Access Partnership would maybe have been following a bit that the process in Australia, which has been led by the ACCC, which in November of last year published, I think it was its 5th digital platforms report in its series of market studies. And that report was released in November last year, and it recommended a range of competition and consumer law changes to address digital platform issues identified by the ACCC in its market studies. And those changes that the ACCC has recommended fall into a couple of categories, and I think it's worth just spelling them out because they pick up on some of the subjects that the other panelists have spoken about. The first, economy-wide consumer measures, which includes a prohibition against unfair trading practices or unfair business practices, a general kind of unfairness prohibition, and also a prohibition against unfair contract terms. The second being consumer measures specific to digital platforms, including mandating dispute resolution processes, obligations to prevent and remove scams, harmful apps and fake reviews and the like, and then a new competition framework, which would have at least 2 aspects to it. The first would be a legislative framework under which digital platforms could be designated, and then mandatory codes developed to apply to services supplied by those designated digital platforms. So that's the kind of summary of the ACCC's proposed law changes. You might be wanting to know where that has gone after the
exactly because I mean
recommendations.
Because right, Kirsten, because I mean a lot of what's coming out of the ACCC, which we should remind viewers is the local Australian competition regulator, they do tend to be thought bubbles, but they have to be embraced by the government, and that hasn't happened yet, has it?
Well, you've got to be a bit fair to the government. It has to allow the processes to progress, James. The ACCC's report was published in November. And from December to February, the Australian Treasury conducted consultation on those recommendations. That's a pretty quick time frame, actually, to call for submissions as to whether those law changes were required. But at the same time, there has been progress on some particular aspects of that bundle of law changes that I mentioned. The unfair contract terms prohibition, which was part of the first category of changes and is economy-wide, that'll take effect in November of this year. So from November of this year, if you include unfair terms in standard form contracts, that will be a prohibition and subject to the very serious penalties that apply for a breach of competition and consumer law in Australia. Just in late August, I think, Treasury issued a consultation regulation impact statement looking at the proposed unfair trading practices or unfair business practices law that the ACCC had recommended. So that is progressing that process. So I think, to be a little bit fair to the Australian government, James, some of the recommendations are being looked at and they're at different stages of their review, and the unfair contract terms one, as I said, is taking effect in November.
Andy, let me bring you into the conversation again. I was wondering if we could maybe pick up on Jan's sort of existential philosophical question. What is the purpose of ex-ante regulation? Why do we need it? What would a regulator be trying to achieve by obtaining these kind of tools and obtaining this kind of regulation?
Okay, thank you. I think I couldn't agree more with what Yan has said, that the most important thing is to make sure or to confirm what kind of goals the competition agency try to achieve by introducing ex-ante regulation. But in our white paper, actually, we kind of holding a more cautious approach to ex-ante regulation. We are still following the issue-driven and case-by-case, applying the rule of reason approach to analyze each cases that come to our office. The reason for that is, first, as the Masayuki has mentioned, the competition in the digital sector is quite dynamic. The future is not that easy to predict. And once you made a mistake, the impact could be tremendous, especially asymmetrical due to the different technology gap between different countries or among regions. So we kind of following a more traditional approach. So personally, I think the purpose of competition law is competition itself. So the main task for a competition agency to perform is to maintain the competitive force, including innovation, that a competitive force driven by innovation. And personally, I think the current trend of development around the world seems to move a little bit from this and to emphasize more on industry policy or policy that traditionally is outside the competition policy. So at this moment, I think we still follow the conventional idea about competition. And also, I think it is related to the debates about what kind of reviewing standard we should adopt, the consumer welfare or the other total welfare, or we need to take some non-competition issue into consideration. But for the undercurrent, the Taiwan Federal is still more inclined to the traditional idea about competition policy. Yeah.
Okay, Andy, let me give you a good example. Andy, in South Korea recently, there have been many steps towards cracking open the ecosystems of Google and Apple when it comes to the app stores to force them to open up to third-party payment providers. That is a very sort of a small aspect of the sort of the broader issue about ecosystems and app stores. Is that not a good example of, I suppose you could describe it as ex-ante regulation? It is looking forward, isn't it, to a structure in which there is insufficient competition within these ecosystems. Is that something that you feel could be considered in Taiwan, taking into account your rather conservative views on this? But do you feel that those kind of steps represent progress in the regulation of platforms?
Yes, I think it is an important issue. And actually, we have a similar case on the investigation right now. But I think that Taiwan, the TFTC, still emphasizes the importance because what South Africa has done is kind of imposing the obligation to engage in transaction with the third party. And for the TFTC, we kind of following the approach that if you want to open up the ecosystem, let the competition do it. So what do we mean by saying that? We introduce new competitor. So we have a case, for example, everyone knows Foodpanda and Uber Eats. Today, right now in Taiwan, these are the two largest food delivery platforms, consistent of more than 80% market share. And recently, we cleared a merger between the retailer and the very, very small food delivery company. And one of the reasons for us to clear the merger is that it encouraged us another food delivery platform to emerge in the market in order to constrain the abuse of market power by these two large platforms. I'm not saying ex-ante regulation is not important at all, but before we come to that, probably we should think about whether competition can do the same thing or not before we jump to the conclusion, okay, ex-ante regulation is good, it's necessary. Yeah.
Well, I think we're getting...
And in fact, sorry, James, I just want to say in fact, a lot of the issues may not be well suited for competition law, in my view. And I quite like Kirsten's highlight on HFC's approach. I mean, there are lots of consumer emphasis, but it doesn't necessarily have to rely on the competition law to address the right and on abuse of dominance to address.
All right, thank you so much. Sorry, I was just getting some other audio in my headphone, but that's now gone away. Sorry if I seemed a bit distracted. Look, indeed. Well, Masayuki, I was just wondering if I could bring you back into the conversation. And US-based global tech companies love invoking Asian jurisdictions, don't they? Because they point to the many established local players. So this is not a world in which the big tech companies out of Silicon Valley dominate the market. For every Asian country, there is a local player. That's as much the case in Japan, South Korea, even Southeast Asia. There are many examples of very, very strong local players. India is another good example. The suggestion is that EU-style regulation, so a sort of an EU-style DMA, wouldn't be appropriate in these jurisdictions because they're equipped for the European context, and in the European context, that the dominance of certain players might be more of an issue than it is in Asia. Do you think that's a fair summary? I mean, is there genuinely a sort of an Asian exception that we're dealing with at the moment?
Yeah, I guess that's partly correct one, but I think the Japanese government and JFTC are considering that point as well. So, for example, we have a pretty strong player in the EC market, like in Yahoo and Rakuten are the examples. Those are competing with Amazon and a global player very vigorously. So they don't actually propose an ex-ante regulation on that market because the competition seems to work pretty well. What the Japanese government sees problematic is a mobile ecosystem market where basically everyone uses iPhone or Google Android phone. Those two companies are very dominant player. That's because their ex-ante regulation proposal is focusing on those markets that cannot basically, where the competition seems not to work in the Japanese market as well.
That said, though, I mean, even in the e-commerce space, there are many controversies in Japan. I mean, one of our correspondents in Tokyo regularly speaks to, I think they refer to themselves as the Rakuten Union. These are third-party sellers on Rakuten who are obviously unhappy with the terms and conditions that they have to face there. So even within those e-commerce spaces, even within local players, there is a strong discussion around antitrust issues, right?
Correct. And I think that's, basically that's based on the specific, clause that the Japanese antitrust has, which is abuse of superior bargaining position, where the JFTC doesn't need to prove the market power of the player. Just the superiority of the bargaining power is a requisite for that clause. And the JFTC often use that clause to enforce against the digital performer. So in that sense, basically, even if the Amazon, for example, Amazon doesn't have much market power, market share in the market, that platform vis-a-vis each stores, they have a superior bargaining power for sure. So that's why they are using that clause to complain about platforms activities.
Kirsten, this may be very unfair, but Australia can be quite inward-looking when it comes to policy development. I'm sure I'm not speaking out of turn here. We at MLEX cover data privacy, and you could really count on one hand the number of lawmakers that have even heard of the GDPR in Europe. I wonder if the same is the case in competition. I mean, how many Australian lawmakers who are ultimately going to be the ones that are going to have to make a decision about this kind of ex-ante regulation, whether or not to bring it in or not. How many of those lawmakers would have heard of the DMA, let alone sort of digested its significance?
You may be just being a little bit unfair there, James, I think. Look, I do think that that our lawmakers do look at developments in other jurisdictions. Certainly the ACCC in making its recommendations, as you have seen from the ACCC reports, it has looked at the DMA, it's looked at what the CMA is doing, it's looked at Japan and other jurisdictions in putting together its recommendations. And I'm not a privacy lawyer by any means, but I think the government's response issued in the last couple of weeks to the recommended Privacy Act reforms does recommend more alignment with the EU data protection laws. So I don't think Australia is a a self-contained policy island. And I do think that lawmakers do have regard to what's occurring overseas. Another example, I think, is the competition review that the Treasury it has announced the task force for to be undertaken over the next couple of years, is including as a specific item having a look at whether we need to prohibit post-termination restraints, for example, which obviously is something which is occurring in other jurisdictions as well. But whether or not, so I think there's perhaps two issues, James. One is whether lawmakers are aware of developments in other jurisdictions, and the second issue, which might be a more interesting issue, is whether developments in other jurisdictions should or can be applied to Australia, which picks up, I think, on some of the comments that the other panelists have made. And I think if you're a policymaker or lawmaker in Australia, I think it would be an error to look at, for example, the DMA, which has been developed in Europe, and say, well, we need to implement that in Australia, holus bolus. Obviously, Europe has very different features in many ways to Australia. Economically, politically, there's a common market, of course, and common political framework in the EC. And from the perspective of a lawyer, European law is very largely civil law, administrative legal systems, very different legal basis from the basis on which law has developed in Australia. The institutions are different, the review and appeal rights are different. And so I think it would be an error strictly from a legal principle perspective to import to Australia a rules-based law that was developed specifically for Europe. I think also you need to take into account, and Australia does need to take into account, the differences in the positions of the digital platforms here compared with in other jurisdictions, and then, of course, the differences between the different digital platforms here. And using just one example, and this is a personal example because I'm an avid online shopper, Amazon came to Australia very late compared with other jurisdictions. And Amazon has a very different position here to the position it might have elsewhere. You might say that Amazon here is the new entrant and driving competition or presenting competition to some of the well-established incumbent Australian retail brands. And for those that like to go to the hardware store, Bunnings is a good example. And the national ubiquitous hardware and home improvement centre that everybody seems to go to on the weekends, and it's now got an online marketplace. And so I think there are all those very important differences, James, between Europe and Australia in terms of the legal systems, the economic framework, and the position of platforms here, and then the differences between the platforms here, which means that I think it would be an error for lawmakers to go, okay, let's just implement a DMA type law here.
Andy, I was going to ask you about a great example of cross-pollination when it comes to policy. I know that that Australia's new media bargaining code has resonated in Taiwan. Tell me something about that. I've always found that fascinating. What about that? And for those who are not familiar with it, this is to force the digital platforms, namely Facebook or Meta and Google, to deal with media companies for use of their content. It's been extremely controversial here in Australia. Why did that resonate in Taiwan?
Okay, thank you, James. Thanks for bringing this issue up, because I think this is the most pressing issue right now in Taiwan in terms of digital competition. Yes, local media, news media, especially the printing medias, they keep on complaining to the government that the digital platform had taken away all the advertising revenue. So they insist on sharing the revenue sharing scheme. And frequently, they frequently cite the example from Australia and EU. And currently, within the government, we have this interagency task force dealing with this issue. And at this moment, we try to facilitate negotiation between the news media and the digital platform. By digital platform, I mean Google and Meta. And we have held several meetings. And Google has, I think, has launched a Google for Taiwan program, in which Google promised to set up a fund to assist the local media, news media, to do digital transformation. But local media actually do not quite satisfied with this kind of result. They're asking the government to do more because they think the media is very important for democracy, and they are kind of below the drawing line. Without the revenue sharing, they probably cannot last for too long. So I think they push forward the government to enact new legislation, something like what has been done in Australia. So there are several drafts in the Congress. Probably on the next session, they will discuss a little bit about it, whether we should pass a law like this. But on the other hand, from the business community, I think there are some different voices in the business community. Especially, we all know there is a symbiotic relationship between the media and the Google, and especially when you take into account the example from Canada, Czechoslovakia, once they passed the law, the Meta kind of canceled the service in the country. So all this kind of stuff has been taken into account, especially in the business community. So the kind of the tug of war debates right now in Taiwan. Yeah.
Oh, those tug of war debates are the ones that we love to cover because they offer so much color and movement and so much excitement. But look, this might be the right time to tell our viewers that if they are planning to drop some questions in the chat box, by all means, start to do that now. Don't wait for the Q&A session to be over. Get in early and post as many questions as you would like. They don't have to be by any means deep and meaningful. They can be quite cosmetic, superficial, and gossipy. We will take all types of questions. Jan,
can I jump
yes,
in?
Yes,
can
please
I jump
do.
in
Please
the
do.
news media versus digital platform issue. We have the similar situation. We have a similar argument in Japan as well. But I think that is basically, because of the failure of business decision by the local media or media companies. Because compared to other media companies, for example, in Japan, Nikkei has very strong bargaining position in the digital media market because from the early stage, they invest into the digital transformation heavily, based to try not to dependent on the digital platform. So that is success. That becomes successful, and actually the Nikkei has much more bargaining power against the news digital platform. So I think that a bargaining power issue is basically the business decision by each media companies. So I don't think we need to help those kind of failure, try to try to make them survive. So that if they fail to do the business decision, they will eventually that result will be they need to take that result.
Thank you so much. Obviously, as the only journalist on the panel today, I am slightly more horrified by recent developments over the past 10 years than any of you on the panel is, and that's fine and that's understandable. I just struggle to see what kind of a business model there will be for journalism as we move forward. But that's not a problem for my people of my children. I've got teenage children. None of them buy newspapers anyway, so I don't think it's really a problem that we can solve here today. But Jan, I wanted to bring you back into the discussion with your usual clinical, dispassionate view. Tell me about the DMA. Tell me across Asia how some of those principles could be applied and whether or not that could be difficult in societies, whether or not it could stifle innovation. I mean, we've talked about Japan's light touch approach to antitrust enforcement in the digital area. Singapore, where you live and work, has a similarly light touch approach. Do you think that this kind of regulation could have an ongoing, lasting effect when it comes to the economics of these countries?
Thank you, James. I'm not sure if I can inspire anyone, but I'm happy to give it a try. Others feel free to jump in. I guess the first thing come to my mind is we know those platforms as global players. So the question is, when some of the players have to comply with DMA or DMCC in UK, they may be forced to modify their business model. And to what extent they can separate some of those changes in the EU and UK from the other usual business in the rest of the world. And that on its own, as economists, you can see that there's less efficiency, reduced efficiency going on, less synergy. I mean, that is clearly not a positive thing. And then one thing always concerns me, even up to now in DMA or DMU, I think UK CMA is much better. I quite like, really happy to hear from Andy that Taiwan Competition Commission is really focusing on understanding the business. So our experience working in this field for so many years is that the business model are often so complex and changing all the time. Even with internal support, people following or working with certain company all the years, sometimes we get surprised. From the team, oh, sorry, we thought we understand the model. No, we don't. So if you look at the EU shopping case and the final court hearing are still struggling on very basic topics. What is Google Shopping? What exactly is Google Shopping product? So I think we shouldn't undermine the complexity of those technical issues. And even as economists, we can't answer those without technical support. So that is very important to bear that in mind if we're borrowing any kind of specific changes into the region, and we have to check whether it's actually relevant and what's the implication to businesses on the ground. The other issue I'm concerned about is the competition on business models. So we talk about e-commerce and people are just jumping to the natural conclusion, okay, those marketplaces are competing against each other. But what is marketplace? So, I mean, that is a big question. Amazon is an old traditional way of presenting products. But nowadays, young people kids go to TikTok, go to Meta to get products. They buy through live streaming or influencers or recommendations. So is it right to completely leave out those platforms just because their core services are not offering marketplace services? So I think authority sometimes gets a bit conservative when it comes to conclusions of what is the market we focus on and what is the competition dynamic. And maybe we should be a bit more innovative in this space if we want to come up with better rules and regulations.
But that doesn't take anything away from the antitrust concerns within the marketplaces themselves. I mean, you've heard about self-preferencing and all of that range of antitrust concerns there, and they seem to be very real. But I take your point that it is often very difficult to see where for regulators to really make sense of the marketplaces. Returning to China, Jan, I just wonder if, in a way, the Chinese government and the SAMR crackdown has been kind of an equivalent of the DMA in a way. I know this sounds absurd, but they've managed to achieve a lot of the objectives of the DMA in one fell swoop. It's all happened very fast and relatively painlessly, not for everyone. But do you see, is that me going too far, or do you think that there's an element of China no longer needing this kind of regulation?
I think it's a combination of DMA and DMCC. I'm not a lawyer, but that's really my reading of it, because the breakup of the company sounds like something UK through market study might come out with the conclusion of there's the issue about structure change in the sector and we might recommend some changes. So I don't know to what extent the DMA would allow the commission to break our company. Maybe they will, but I'm not sure. I'm not best placed to answer that. But certainly what happened in China goes beyond behavioral remedies, and there's some structural changes going on. Has it gone too far? And there are lots of issues going on in China besides the digital sector crackdown. So it's a bit hard to say, okay, what the problem we are facing now, all driven by the crackdown by the government. but certainly we do see a lot of cautious approach by the players in the sector in terms of developing new products and mergers, acquisitions, or partnership, etc. So that is feasible. If you call that being over intervention, I would agree.
Yes,
I would agree with
indeed.
you.
Well, it's certainly had a remarkable impact, hasn't it? Andy, I know from our coverage of Taiwan that the issue that you mentioned before of MFN clauses, so most favored nation, has been discussed intensely by the TFTC. Let me just briefly explain for those unfamiliar with these clauses. MFNs, also referred to as parity clauses in the context of digital antitrust, tends to focus on websites such as, for example, booking.com or Expedia. And it comes down to a discussion about whether clauses that limit a third party's ability to advertise lower prices elsewhere, whether or not those clauses are anti-competitive. Now, we don't need to get in too much detail here about narrow or broad parity clauses, but could you tell me something about how that issue has played out in Taiwan and why that has been a significant area of involvement on antitrust?
Thank you, James. The reason for we to put the MFN clause in the white paper is it is quite commonly practiced in the e-commerce industry. And recently, we just sanctioned Uber, Foodpanda for adopting the most favored nation clause. And the case dealt with the narrow, what we call the narrow MFN, because the Foodpanda required the restaurant to follow his policy of the in-store and the delivery must follow the same price. So they try to equalize the price for consumption in the store, in the restaurant, and for food delivery. And that kind of practice is what we call the narrow MFN. And usually, and in theory, narrow MFN is treated more leniently than the what we call the broad or wide MFN, because wide MFN could lead to market collusion and the price fixing all around the market. So this case has evoked several debates and discussion in Taiwan, and the case is still is pending in the court. And the reason for we to punish the Foodpanda is that by following this kind of narrow MFN, it weaken or even eliminate the possibility of challenging the market power enjoyed by Foodpanda at this time, because the user, the consumer, won't have any incentive to shop, to dine in store, because the price are all the same. We know this for the platform, the opportunity to challenge the market power from a platform is to engage in direct transaction, and this kind of arrangement has eliminated that possibility. So the case is pending, and we are looking forward to the court to support our position. But in addition to the food delivery platform, we still have other cases that are dealing with MFNs, and we are expect to see more in the future, especially in the retailing industry. The retailing industry required the supplier to follow the MFN clauses. Yes. We have a couple of cases there. Yeah,
it is a tricky one, isn't it, Andy? Because on the one hand, you're no doubt aware of the risk of free riding, of people looking up what they want to eat on, Uber Eats, then deciding they want something, they contact the restaurant directly and hope to get better prices there. I mean, for innovation to work, for these digital companies to make a profit, they need a business model that works, right? And so you must be terribly aware of that. On the one hand, you do want to deal with anti-competitive problems, but on the other, you don't want to stifle innovation.
Yeah, sure, because we have a dissenting opinion in this decision. So some of the commission are concerned about the innovation issues, especially this is a new business model. But I think there's one critical point in this case is that when the Foodpanda signed a contract with the restaurant, there are several restaurants. When the contract was signed, they were only the Foodpanda was the only food delivery platform at that time, because Uber Eats did not enter the market 3 years later after the Foodpanda entered the market. So it kind of strengthened the Foodpanda's power in negotiation with the restaurants. That's part of the reason why we think this is worth our consideration and regulation. Yeah.
Let me remind our viewers and listeners that the time for them to post a question in our chat is right now. You're going to run out of time if you don't do it soon. So I'll move on to some of those questions very, very soon. Kirsten, more broadly on the issue of anti-competitive self-preferencing, particularly in the context of platforms preferencing their own services over those of third parties. There are a couple of interesting cases bubbling away in Australia dealing with this very issue at the moment. The ACCC has pointed to concerns on this front in the past. What is, very broadly, the state of play in Australia on this front?
Yeah, it's a good question, James. I think in the ACCC's digital platform review series, the ACCC certainly identified anti-competitive self-preferencing as conduct that is needing ex-ante regulation, as well as anti-competitive tying, conduct like exclusive pre-installation and default agreements that hinder competition. But I think in terms of the state of the law, as Andy and Masayuki are saying in their respective jurisdictions, I think the current law applies and is capable of dealing with concepts like anti-competitive self-preferencing. And I say that, and particularly so in Australia, we have a prohibition that is called the misuse of market power prohibition. It used to be had quite difficult elements to it. That was changed some years ago now. And what is prohibited is a person who has market power can't engage in any conduct that has the purpose or likely effect of substantially lessening competition, which is a broad and I think quite powerful tool, which is certainly capable of applying to anti-competitive self-preferencing, anti-competitive tying, any exclusivity sort of arrangements that hinder competition. And that tool has been little used so far by the ACCC. It's certainly being used in the current Apple, Epic, Google litigation with some other tools. But I think my own view about anti-competitive self-preferencing, particularly as it's been said to relate to digital platforms, is that our current law is well capable of dealing with it. It's the assessment of whether something is likely to substantially lessen competition is a forward-looking assessment. You have a look at, what's the likely future state of competition with the thing you're looking at compared with the thing if it wasn't there. The ACCC itself has acknowledged that self-preferencing isn't innately anti-competitive and sometimes can be pro-competitive and deliver benefits for consumers. So that's my view of the state of play in Australia, James.
Fantastic. In fact, this might be a good time for me to quote one of our viewers today. It's Christina from the ISEAS think tank in Singapore. This question is for anyone or everyone in the panel. What is the current thinking around the use of algorithms or AI capabilities in the anti-competition space? Do you think there will be ex-ante regulations on the use of these tools in the future? It's interesting because Kirsten's discussion about the effects legislation in Australia could be applied exactly to this case. But Masayuki, I haven't spoken to you for a little while. So do you have a view on AI and the kind of anti-competitive or competition impact that it might have?
So yeah, I don't know much about how the AI will evolve in the future. So I'm not sure I'm in the good position to argue that. But the JFTC has been considering this issue as well in the context of the collusion, the cartel issue, whether or not the AI cartel is established or not. And basically, I think the JFTC's position or JFTC's research branch position is that it could, if technology is evolved and established. But we'll see, and I don't have any specific position on that as well.
Yes, Andy, the notion of colluding computers must be something that keeps you up at night. What's your take on all of this?
Yes, indeed. I think at this moment, we pay a very close attention to the development of AI and its relationship with competition issue, especially the use of algorithm to facilitate collusion. But in terms of ex-ante regulation, actually, it is not on our agenda yet. But within the government, especially other regulatory agency, we do have a very frequent and regular discussion about the AI development. Actually, again, we have the interagency task force within the government. We have regular meeting to discuss, and each agency need to kind of sort out what kind of impacts AI will impose on your agency, and we exchange the information. And probably, and it is quite likely, that the government might propose an ex-ante regulation concerning AI in the future, because the government is very concerned about not the competition, but about the use of AI to disseminate misinformation, especially when we are going to have an election early next year. So
yes,
this type of misinformation is very important and might be detrimental to the fairness of the election. So I think the government pay very close attention to AI. Yeah.
Andy, I have another question for you from a viewer. With app developers, it is in fact from Yonex, one of my China reporters based in Hong Kong, Yonex Lee. With app developers being more frustrated with Google and Apple charging high commissions on in-app payments across Asia, I'm wondering if the TFTC is looking into that issue as well. For example, any formal complaint being reviewed at the moment, ?
At this moment, I can only say that, yes, we have a case. We are investigating about the in-app payment arrangement right now, but I cannot reveal any more details because it is currently pending in our agency. So yes, we pay close attention, and there's a complaint. Yeah.
Okay, then so there is a complaint. So that's good for us to go on. Thank you for not revealing too much, although we're always hopeful that maybe you will reveal too much. Another question here to the panel: do sustained supernormal levels of profitability remain a prima facie indicator of market failure in the digital age? I'd promised our viewers that we would only use ex-ante as the only Latin that we were using in this discussion, but maybe that's a question I can put to you, Jan. Is that something, supernormal levels of profitability? Do you think, as an economist, obviously bringing your credibility as an economist to the table here, are they an indicator of market failure in the digital age?
Well, obviously, if other conditions are equal, we could argue the supernormal profitability is a good indicator for market power or substantial market power. But my concern is which profit we're talking about. So when we analyze antitrust cases, we are focusing on particular market or markets. For digital platforms, there are lots of cross-subsidizing going on. And it is really, and there are different issues on their tax regime and how they apply taxes in different countries. So how do you measure the relevant profitability? That's a big question to me.
Indeed.
In fact, I think I do see, if there are strong evidence of such, it is alarming, because often digital sector players found it difficult to be profitable. They often have to come in to offer free goods to attract users, to maintain the user stickiness, and then find other ways to generate profits. So yeah, on the principle, it's a worry, but we have to see.
All right, we've only got a few more minutes left, but Kirsten, this one's definitely for you. For jurisdictions like Australia that use the substantial lessening of competition test, is it difficult to prove anti-competitive effects in the digital space, particularly with free products? What's your view on that?
I think that, as a lawyer, I always go back to the principles. And I think in principle, you can apply the quite standard analytical framework to what are described as free products. Are they really free? There's the question of, well, you're in a sense exchanging your data for the use of the free product. So I think that the fact that a product might be free, and it might be something that you use a digital platform without paying for it, doesn't mean that it's not possible to assess whether or not there are anti-competitive effects arising from particular conduct. But you need to apply the pretty uniform framework of what is the conduct, in which market is it occurring, and then assess it in that way.
All right. Sorry,
Can I just jump in?
Yes,
Yeah,
please do.
I mean, this is really very good question. I totally agree with Kirsty on this. In fact, we have worked on many cases where products are free. I guess there are two questions. One is SNP test, the framework, also apply to non-pricing features, which we can look at, as Kirsten pointed out. Another point I want to add is the fact that often when there's a free product, it's indication the market might be multi-sided. So you might also want to look at the connecting side of the market and try to figure out the externality between the users and the dynamic and possible way of measuring pricing effect elsewhere.
All right, look, I'm afraid we're out of time. We'll have to book another few hours a bit further down the track to continue this discussion. A lot of fantastic questions coming through that I'm not going to have a chance to get to, but thank you to all of the people who have written in. Thank you especially to the four panelists: Kirsten Webb, partner at Clayton Utz, Yan Yu, partner at APAC Economies, Masayuki Atsumi, partner at Miura and Partners, Dr. Andy Chen, the Vice Chairperson of the TFTC, who joined us on a public holiday in Taiwan today, so deserves special credit. And that's the same can be said, I think, in Japan, right, Masayuki? So I really appreciate you taking the time. I certainly would like to thank Access Partnership for making this all happen. And thank you to you, the viewer, for taking time out of your busy day to watch this streamed event. My name is James Panichi. I'm a journalist with MLEX. It's been a privilege to host this event, and I hope to see you again very, very soon. Thank you. Bye.
And on behalf of Access Partnership, I also wanted to thank James for his moderating, but also for moderating on his birthday. So happy birthday, James, from everyone.
Happy birthday, James.
Happy birthday.
Thank you so much.
Thank you, everyone.
Thank you.
Thanks,
Thank
everybody.
you. Thank you, everybody. Thank you, James. Thank you, Jonathan.
Thank you.
Thank you. Bye-bye.
Bye-bye.